If you've been sued in circuit court by a debt collector or a debt buyer, you may face something that's called a motion for summary judgment. And all that means is a motion is where you're asking the court to do something, and you do that in writing. And so the debt collector will ask the court to enter judgment in its favor. So it does that in writing with a motion, and it lays out some facts and some law, and it says, as a practical matter to the judge, look, judge, no reason to have a trial. We don't need for your honor to do this, and we don't need to have a jury consider this because no reasonable person could ever rule against us. In other words, the only reasonable result is that you enter judgment for us, the debt collector. That's what the debt collector is saying. And so once they submit the right type of evidence that complies with the rules and the law, then the burden shifts to you, where the court's looking at you saying, okay, it looks like this debt collector is right. Now you show me why they're wrong. And again, you have to follow the law and the rules of civil procedure to show the judge, now wait a minute, there is a question of what's called material fact. And that is where the judge can't just look at the papers and say, oh, this person's right or that person's right. Instead, we need to have the actual trial to decide. So you can think of it this way. A summary judgment, it's almost like the judge is saying, imagine there's a jury there and the judge is saying, look, there's no reason for you guys to even consider this. I'm summarily entering judgment. And in trial, we call that sometimes a directed verdict, where the court's directing the jury, here's what you must decide, because there's no other reasonable option here. So the summary judgment, if you lose that summary judgment, there's no trial. Your case is over. Sometimes people get upset about this. They go, but wait a minute, I want my day in court. Well, if the judge enters summary judgment, there is no day in court. You lose. And so if you get one of these, what do? Well, you have to follow the rules. The rules are somewhat complicated for the timing of when you respond, how you respond, the way that you get evidence in front of a judge, and you have to follow all those rules. And the thing is that the debt collector, the debt buyer, can submit affidavits. That's just a written out, sworn statement. That is allowable if it's done correctly. And I'll say this, they normally don't do it correctly. But if they do it correctly, then that can be evidence at the summary judgment stage. Now at trial, you really can't use affidavits because you can't cross-examine a piece of paper. But understand that it's very easy for a debt collector to submit the proper evidence, even though they normally don't do it. But it's easy to submit that at the summary judgment stage, much more complicated at the trial stage. They got to bring in this witness and this other witness to try to prove their case. So if you're facing summary judgment and you're doing this on your own, that can be very challenging. If you're going to do that, it's fine. Just make sure you understand the rules of civil procedure, particularly Rule 56 is what summary judgment is, and you understand the law and understand what is your burden to prove and what's the burden to prove on behalf of the debt collector or the debt buyer. So if you have questions about this and if we can help you, give us a call. My name is John Watts, 205-879-2447, or you can reach us through our website, alabamaconsumer.com. Thank you.